Hello, everyone. This is Stephen Futerall, and you are watching another broadcast of Legally Speaking. We're glad you could join us this afternoon. We're going to be joined by Kimberly Sands, who is a mediator in Florida, has been practicing law and presumably mediating for a little over 30 years now. And today we're going to talk a good deal about successful negotiation strategies, and we're also going to talk about alternative dispute resolution, namely the process of mediation. Before we get to all that, I have a couple housekeeping matters. One, you know what's coming, don't you, Tina? What do I have?
Absolutely, yeah. I almost drug out my water bottle today, but I was too lazy.
Okay,
Actually,
well,
I didn't want to drive back home and get it and come back. So.
That's all right. I've got coffee in here for both of us. I want to give a shout out to our supporter. That is Rocket Matter, which is the leading cloud-based solution for small to mid-sized law firms. If you are in the market for a good practice management solution, look no further than Rocket Matter. Learn more by visiting rocketmatter.com. With that, I'm going to take my obligatory swig of Java, a cup of Joe, from my Rocket X1 cup. Hold on.
That looks like it tastes so good.
Actually, I feel like I need to cough, but it has nothing to do with Rocket Matter. Excuse me, coffee the wrong way. Anyway, Tina, we're joined, of course, by my charming and talented co-host, Tina Willis, who is from Florida. Tina, how are you today?
I am doing great. I'm feeling more guilty than I was feeling the last time we met because I think this is the first time in about 7 or 8 months that I have posted nothing on Google Plus this entire week.
Shame on you.
I've been slammed with work, but I don't plan on making that a habit. I just had, like today I had 4 deadlines, so there was no room at all to do that. But I'm going to be tomorrow. I'll be back. So right now I'm back.
Everybody, all of our supporters and friends of Tina, show her a little bit of love. Tell her it's okay to have a life outside of Google+. For example, I haven't posted a whole lot. I've redesigned our firm website, which took some time. And you can always tell when I'm wearing a tie, I've been to court. So I drove halfway across South Carolina to make it back on time, just so we could all hang out together. So I want to go ahead then and turn it over for a little bit to Kimberly Sands. Kim, how are you today?
I am very good. Thank you very much for having me.
Now, how close are you to Tina? Because she's in the Orlando area.
Yeah, miraculously, we found out that my guess is we probably have offices within 10 miles of each other and have never met, which just blew my mind.
See how Google works. Now it brings you together. You're practically across town, and I think lunch is on Tina because you decided to join us today.
I like Stephen already.
Yes.
So, Kim, did I get that right? I know you've been practicing for over 30 years. How long have you been a certified mediator?
I was certified in 2001 and was full-time as a mediator by 2003, so a little over 10 years full-time. Prior to that, I was a litigator and mediating, as an advocate as opposed to a professional neutral. So the 31 is correct. I've been trying to analyze and break down this process so, first I could do my best for my client, and now that I can do my best for both parties or however many parties present themselves to me in mediation. So long time.
Well, before we get too far into the topics we're going to talk about today, for those folks who may be joining us who don't know what mediation is, Kim, would you be kind enough to explain to our audience what is mediation, and in particular, how is that different than going to court or, for example, the other form of alternative dispute resolution, how it's different from arbitration?
Right. It is an alternative form of dispute resolution. Arbitration, you turn decision-making over to an arbiter or several arbiters. It's a paid process through arbitration. Trial is turning decision-making either over to a judge, well, certainly a judge as a threshold, and if there are factual matters that both parties want to have considered by a jury, ultimately a jury. So disputes are then resolved by some third party whom we don't know and we can't control. I always thought that was the crazy part of what I did. And so with mediation, what happens is the the people who determine the outcome are the parties to the dispute, not their attorneys, although certainly their attorneys help them, but the parties who actually have a dog in the fight. And so it's a voluntary process in which parties come together with the assistance of a neutral. My job is to facilitate a conversation both about what they need to be thinking about when they're making a decision to settle or not to settle, but more importantly, what are the opportunities for settlement, and can I get both parties to yes when historically they've been saying no. But the biggest distinction is that the parties are the deciders, not a judge, not an arbitrator, not the jury.
That makes perfect sense. Tina, y'all both are in Florida. Do y'all have any form of mandatory mediation, much like we do here in South Carolina? A lot of cases are required to mediate within a certain period of time. How about in Florida, y'all?
In Florida, I think many people think we have mandatory mediation because it's kind of the practical effect that it's mandatory. We have a statute that governs mediation and a rule of civil procedure that governs mediation. There are some cases that are exempt. Don't ask me to list them because obviously I don't mediate them. But for the most part, judges like mediation because it clears their calendar. And statistics say that most people are more satisfied with the judicial system and the outcome of their case when it's resolved through mediation. So there's a lot of big pluses that, and it's a huge money saver. So there's a lot of reasons why everybody now goes to mediation. Most judges really won't let you go it won't give you a trial date, won't let you go to a jury. Unless you have mediated, and sometimes mediated more than once. So it feels mandatory to the parties and to the litigators. We also have voluntary mediation. I do a lot of pre-suit mediation where people know they have a dispute and their counsel sits down with them and explains to them what their options are, and we do have an ethical obligation to explain what the alternative means of dispute resolution are in Florida. And so an attorney sits down with the client at the very beginning and says, these are your options. Maybe contract requires arbitration, but you might be able to pick up the phone and say, let's do mediation instead. Or it may say we require mediation, or it may say nothing. It may be silent on the subject, but because of the knowledge about the expense that's involved and the risk that's involved and the time that's involved, mediation turns out to be a better option for many, many people than arbitration or litigation.
Absolutely, and Kim and I, for the audience, and Tina knows this, Kim and I were discussing the fact that likewise, like her, one of the things that I do is mediation. I've been certified as a civil court mediator since 1995, and also a family court mediator for many years as well. And Kim, you bring up a good point about the benefits of mediation. When people ask me about this, in a nutshell, I will tell them less costly than litigation. You get to control the outcome of the process. It might not be everything that you were hoping for when you go into the trial of the case, but Kim, I'm sure you'll agree with me, you can craft a resolution in your case in ways that are creative that a judge or a jury can't do for you. It's usually kind of a black and white outcome where you can get very creative in the mediation process. And lastly, you have some control over the outcome. You can always decide not to settle your case, for example. That's some control, and go ahead and proceed to trial. But I think between those three things, most people find mediation far more beneficial and satisfactory than going to trial.
Well, obviously I agree, I'm a bias, but I also think that you can learn things about your case that make your decisions more informed, so that even if you choose to take the risk of turning decision making over to somebody else, you've at least had the opportunity to make that evaluation on an informed basis by listening to both sides, understanding what a judge is going to hear, what a jury is going to hear, and even if you don't settle, I think there's value in that.
I was wondering, do you get many calls from non-lawyers, from just people who have disputes without lawyers wanting, to go through some sort of mediation process? To either of you Or does that just not happen? Because I see some attorneys who actually advertise as, like we have a local attorney here who, I forget the name of his practice, but it's, mediation-centered title. Mm-hmm. It's like, do you just get calls randomly? I've been meaning to ask him, but or does that not happen much?
It depends on the type of mediation you do and what your reputation is. I have gotten calls from other professionals who their attorney has said, you don't need me, you need a mediator. So I have negotiated dissolutions of partnerships, dissolution of family businesses, where the attorneys don't contact me. I always think it's a good idea to have an attorney, but if cost is a factor, getting together with a mediator is probably safe because what we do is confidential. I don't do family. Family is a different.
Yeah, and this is what this man does.
But
what I was speaking of, yeah, he's a family law mediator.
I can get calls from insurance adjusters. I can get calls from business people. I can get calls from in-house counsel. It doesn't have to necessarily be the litigator who is contacting me, but I would say the bulk of my business is contact through the litigator.
Mm-hmm.
Tina, likewise, a lot of my mediation comes from lawyers who are trying to select a neutral to decide, or not decide, obviously it's mediation.
Inform.
They decide on a mediator and
correct misconceptions.
But listen, having said that, I do, in the family law arena, I do get calls from husbands and wives, and typically they're getting along okay, but they have some issues they need to resolve. Typically they're financial in nature, and they want to avoid the cost of litigation or even hiring an attorney. Now, this is where, Kim, and you probably can jump in on this as well, we're walking a bit of a fine line. I explain to people, look, I'm not here to give you legal advice. I can tell you there are different forms of mediation. There's purely neutral, where you do not basically give your 2 cents worth as the mediator. I practice a different style. If the parties want to hear from me what my thoughts are about the outcome of the case or what I think the law is, I will freely share that with them. They can kind of take it or leave it. So in family court lends itself well when there are not contested issues of custody and so on. In other words, the emotions are not too high for people to really save money in the mediation process.
One of the reasons I asked that question was, of course, and Kimberly, you may or may not know this, sometimes we have non-lawyers watching our show, and I'm always trying to think what they might be wondering, and is this something that they could utilize if, like you said, if costs were a factor, particularly in family court. But Ray Miller has a question here. You probably saw it, Stephen. How about if a will is contested?
Yeah, those are fun. Those are fun. Yeah, those are very similar to the family cases in the sense that these people know far more about each other than they share with their attorneys, and you will ever know about them. And they can be very highly emotional. But yeah, I've I've mediated a lot of contested will cases. That's actually a good place to go, particularly when you're worried not only about informed decision making, but to the extent possible retaining some family relation.
Right.
So sometimes in business, sometimes in family, you say to yourself, some things. I shouldn't say this probably. It's always about the money. Let me just say that. No matter how many non-monetary terms come up, it's always about the money. But you can't forget the non-monetary terms that exist. And so the relationships that might exist between, business people, between families, you deal with those. Those are things we deal with all the time. And it's an important piece of probably any mediation, not just those that lend themselves to highly emotional or highly personal issues.
I wanted to clear something up, and then, Kim, I've got a follow-up question to kind of expand on it. And what I wanted to clear up for the general public is this. It is the perception that mediation takes place in a way that doesn't happen in reality. I'll give you an example. I was watching a television show, The Good Wife, the other day, and on that episode, they were conducting mediation, but the mediator was acting as a judge. It was actually an arbitration, and the mediator was allowing the parties to really go at it essentially across the table from one another. And Kim, help me out here. That's not the way we conduct mediation. That's not how you get cases settled. Right.
No, it's good entertainment. A couple of years ago, there was a show called that was about a female mediator, which particularly offended me because the woman wore Christian Louboutins with like 6-inch high heels. Well, you can't do that.
Yeah. If you don't settle your case, I'm gonna spike you in the head with my stiletto, right?
Yeah. Because you got to walk back and forth between the caucuses.
Oh no, you want comfortable shoes, no question.
There you go. The only thing mediators absolutely control, from my perspective, is the process.
I thought you were going to say their shoes.
That too.
That's a personal preference, but I prefer flats. But we control the process, and there is probably not a lot that I can think of ever there being any good reason to let people go at each other. You are there to protect both sides. You are there to have a constructive conversation. And when things start deviating, it's a great example on television or in the movies of a good mediation is The Wedding Crashers. The scene in the very beginning where it's a family mediation, so you should see it, Stephen. But there are two mediators there, and some cases do lend themselves to two mediators for various reasons, husband and wife, and they were just going at each other. And all the guys were talking about was, but there were good times, weren't they? The wedding was great, the food was great, you had everything going for you. And suddenly the tone started turning until the very end. The husband gives up his frequent flyer miles to the wife, which they had been fighting bitterly over.
Yeah.
Said, well, that's great. Maybe you can share a few with us. And the husband says to him, would you just shut up now? Which, to me, was exactly how mediation goes. You try to get them away from the destructive conversation and pursuing the constructive conversation. And it was entertaining, but it was also probably more accurate than anything else I've ever seen depicted in television or movies with respect to what we actually do.
Yeah. We had here a question from Christopher Vogelman, and he says it's a less than theoretical question. How does a spouse of an attorney protect herself from a professional fabricator and emotional abuser? And Kim, that might be a little bit off topic, except to the extent that perhaps we can address it in the context of, oh, I'm sorry, he also says spike the drinks, but not your heels.
Yeah.
Good one, Chris.
No drugs or alcohol. It has to be a free decision without benefit of any kind of influence.
Absolutely. I do not serve cocktails at my mediations. I don't think that
Sometimes I think we need them, but no, we don't do that.
Kim, can we put this, to answer Chris's question, can we put this in the context of conflict resolution? Tina, Kim and I were talking a little bit before the show, and this is, and I had written a post about this, law school teaches us so many things.
I remember that post. I know what you're going to say.
Yeah, but not how to resolve conflict, which is whether it's conflict between two lawyers going at it in your mediation, a husband and wife going at it in mediation, and that sort of thing. Kim,
by the way,
this person added a level of difficulty of the other party as an attorney, and that to me raises a lot of red flags in terms of the representation they receive, the venue that they're in. It does not raise red flags with me with respect to mediators. Because if you have a mediator who has a reputation for being professional, they're going to know their obligation is to be neutral. And that's not going to be an issue, as far as I'm concerned, for the mediator. But it is an issue for the party, I think, going in and finding representation that is going to give them good independent advice, and a venue with a system that's going to give them an unbiased review of the facts and the law.
Yeah. Well, I will say, Chris, also to jump in with Kim here, based on my mediation background, if there's an imbalance of power going on during the mediation, then a skilled mediator is going to level that playing field. They're
Right.
going to give both parties an opportunity to express themselves. They're going to take the time to get past the rhetoric, to get past the manipulations, and to get to what the real issues are for both parties, even in an imbalance, and keep it neutral, as Kim indicated, and keep it level.
Well,
So,
and the other thing is, of course, that person probably needs their own attorney who hopefully can offset the professional fabrication and help find ways to avoid the emotional abuse. I mean, to remove her from the situation or tell her how to get herself out of it. But
Well, and it's why mediation actually might be a good sounding board for that, because one person's professional fabrication is another person's evidence at trial, and you know, you just don't want to end up getting hung up on stuff that's destructive and is not going to produce informed decision making.
we have a question here, by the way, from Stacy Roberts, which, Stacy, this issue, thanks for asking this question, that's kind of come up here as well, which is, are there many retired judge mediators in Florida? She says it's a hot topic where she practices mediation, which is in Utah, and they say that they tend to have a different style approach to mediation. Stacy, that is a very diplomatic way of saying they tend to act like judges in mediation, in my experience. But anyway, Kim, Tina, what's y'all's experience there in Florida? Are you seeing more retired judges acting as mediators?
We have retired judges who are members of Upchurch, Watson, White, and Max, and I'm sure they're excellent. I'm sure all of them are excellent. When I went through my training, when I was mediating, there were some judges who made excellent mediators, and there's some people who actually need to hear an opinion, not one opinion, but you mentioned it before. You know, sometimes you share your training and experience. That's something you can offer, a neutral perspective. But then there are other judges who think that's the process. They think they're there to decide, and that's not going to be constructive. If you have a judge who understands that there's a process there, as well as a sharing of experience and even opinion, but no legal advice and no guarantees, that's what you're looking for. So I won't condemn all judges, but I understand what Stacy's saying.
Yeah, and likewise, we have a similar situation here where there are a few mediators who are former judges, and albeit they are very well intentioned in their approach, I have, in some cases, the clients feel a little bit intimidated by that. They feel like they've lost control of the process because they're mediating with a former judge. Having said that, we have a wonderful mediator here in Charleston, Bill Howard, who not only was a circuit court judge for decades, but went on to be a judge for the South Carolina Court of Appeals. So then decided for his own reasons to go back in private practice, and I will tell you, makes a wonderful mediator. Doesn't express that thought unless you ask for it, but otherwise remains neutral. So.
Yeah, the senior partner of our firm is a retired judge, and he's the exact same way. He doesn't like being called judge, although in Florida, we typically use it as a courtesy title for retired judges, but he understands mediation. And if you understand the process, then you might use what you have in terms of your training and experience and your background and things like that, not to unduly influence somebody, but to help somebody work through the informed decision-making process. The idea that if we don't resolve it here, your alternative may be turning it to somebody else who will make the decision for you. And it's helpful sometime to have that reflected back to you.
I actually have a question I came up with. I'm just wondering, you know, you've seen lots of mediations, obviously. And what ways would you say lawyers could more effectively utilize mediation, or when they're there, you know, could do more with the process?
How much time do we have? I mean, that is a topic unto itself. I have seen I've seen extremely good lawyers who know how to talk to a judge, who know how to talk to a jury, don't know how to talk to their adversary, don't know how to talk to the opposing party. We in Florida have a process by which when we first started doing this, we called it the event. Everybody has to get together. Now we have an order that says everybody has to be there in person. And it's good because you have to look at the people across the table and have a conversation and listen to what both sides has to say and say, okay, that's what a judge is going to hear, that's what a jury is going to hear. I am surprised. No rules of evidence, keep in mind. No judge watching and saying, you can't say this, you can't say that. And yet so few litigators take the opportunity to truly craft an opening statement that is designed to be persuasive to their audience, who admittedly is somebody inherently biased against them, but that shouldn't stop you. You should take that opportunity to begin planting the seeds of why you think you have the better story. And so often that's not done, or the opposite is done, where they just vent on what a lying, cheating, dirty, terrible company you are, a scum you are, whatever.
So we never hear that at all.
No, never hear that. In which I say, okay, I think the conversation is not constructive anymore. Let's break up into smaller groups. You need to. I guess the simplest way to say it is consider your audience. Consider what you're trying to accomplish. And it is possible. This is a human institution. It is possible to influence people who are inherently biased against you. The more you know about what those biases are, the more you know about what facts of the case may be influential, the better you are. And you should share those things in opening, but you should do it in a respectful way, and you should pay the other side the courtesy of listening. I had one. Can I tell a war story?
Absolutely.
Okay.
Absolutely.
I had one.
Love war stories.
Okay, good. I had one situation in which a gentleman had lost his leg in a car accident, and he was parked off on the side of the road, trying to do some work on his car, and another vehicle cut the corner and took off his leg. And there was a day in the life video. For non-lawyers, that's a usually professionally produced video that goes through what it's like for this gentleman to live without a leg. And he was a good old boy. He was a trucker in Florida, probably hadn't cried a day in his life, but he and his two sons, who were chips off the old block, cried throughout this video. It was painful to watch. It was good theater. During the entire presentation by the plaintiff's attorney, the defense attorney had his head in his computer. And when it's time for him to present, his head pops up, and all he can talk about is how this guy shouldn't have been lying on the road, and what a great life he has now because Medicare got him a new leg. He had missed everything that was in that video. Now, I might say in that situation, stay away from damages. There's nothing you can do about it. But I'm so sorry this happened to you, and I'm so impressed at how well you were doing. I am so impressed by your sons and how supportive they are. It's confidential. Nobody's going to ever know you said that, but that might do a lot to telling the other side that you listened, you heard what they had to say, and you still don't feel that they are entitled to the compensation that they think they're entitled to.
Do you have any war stories in the reverse where plaintiffs' attorneys have done something you consider to be not good, or any advice you would give to the plaintiff side of it, something they could do better?
With plaintiffs' attorneys, I think the biggest sin in a joint session is not listening. You should always listen to what the other side says. And even if you have to change your presentation, you should change based upon what they've said, because they've told you some incredibly important things. Now, the plaintiff gets to go first, and may tell you some incredibly important things. The defense gets to go second. They get to respond. They frequently don't. But from the plaintiff's point of view, it's the same thing. The other people on the other side of the table are probably there in a professional capacity. In most cases, the defense is either a representative of a company or an individual and their attorney. And there's no reason to treat them any other way than professionally. And I see a lot of people not doing that. Once again, not considering your audience and not using that time that you have to be persuasive constructively. I did have one guy who brought a gun in. But,
yeah, that's always a bad sign that mediation may not go the way you thought it would.
He had his own way of dealing with this, and I said, what's that? And he pulls up his pants, and I see the gun on his ankle, and I said, okay, we're done. Would you mind exiting, in the back?
Yeah. So, yeah, no packing heat to my mediation.
Yeah, that's probably a good rule. But plaintiffs just don't use the opportunity constructively. They come in with the same canned thing. They worked with the same person over and over and over again, so the other person is asleep within 3 minutes. I think the best presentations I've seen from plaintiffs is where the plaintiff demonstrates that they actually know their client and know their case. And when you do that, the other side has to say, do I know my case as well as that? And the answer is almost universally no, because it's a different relationship. But when you do that, and from my point of view, that person is capable of trying that case. That person is capable of making that story.
It's such an interesting dynamic to go, Tina and Kim, to go back and forth as I do between litigation and being a mediator. So if I'm in mediation on behalf of my client, as Kim was indicating in her comments about listening to the other side and so on, I've got a few key goals that I want to establish. One, no matter what the case is, I want to present, if we're given an opening type statement in mediation, some types of cases, yes. Family court, they usually split us apart right from the get-go. That's how we do it here. But if I'm given an opportunity to speak on behalf of my client, it's an opportunity for us as lawyers to show the other side that we are prepared to go to trial. As Kim indicated, that we know our client, we know our facts, we know our law, so win, lose, or draw, this truly is our best opportunity to avoid litigation because we're ready to go. Also, in those cases that don't settle, if I listen, I find out a lot about my case. It's much like if you try and proofread your own writing, you will read the wrong words in there and miss those typos every time because you're just sort of conditioned to looking at it the way you've been thinking about it, which is the same thing that is true for your cases. And until you actually open your ears up, listen to the defense and their counsel, even if you don't appreciate their position, it gives you a different perspective and one that may help you if it doesn't settle at trial. Kim, right?
Yeah, absolutely, and it works both ways, and it's sometimes why I'm disappointed when representatives come who don't have authority, because being able to see that, having a glimpse of what's going to happen going forward, I think is extremely useful, as well as being able to make decision-making on the ground. Yeah. And yeah, you listen because there are opportunities there either to be informed and to adjust either your evaluation or adjust your theme. It's the way you communicate.
Yeah. By the way, Ray Miller had a question here. Tina, we've got some questions coming in. Ray Miller wanted to know, what do you do if you get a former judge who's not a mediator who crosses the line and becomes a judge again? Is there an appeal process? Kim, either one of us can take this one, but go ahead.
Well, in Florida, we do have professional rules of conduct, but you're talking about a subjective thing, because I am sure that everybody has a different way of going about things, and the only way that I know a judge can actually exceed their authority is if they tell you you have to do this and they're going to enter an order requiring you to do it, and that doesn't happen. If what you're saying is that the judge comes in and says, well, I think you're full of you-know-what, and you're never going to get that much on this case, or you're going to have to pay more than this on this case, or whatever it is they're saying to you, don't use them again. If you find that troublesome. I'm not sure I would say I find that unethical or even particularly surprising.
Yeah, by the way, Kim, Ray Miller is actually in South Carolina, Ray, and here in South Carolina, mediation, whether it's court order that you participate or you've decided to do it without a court order, settlement is voluntary. No one can twist your arm to settle. An effective mediator is going to get both parties in the middle. Think of a Venn diagram. When I'm mediating, I look at all the central issues. We weed out the emotional ones, etc. And as Kim indicated, it usually comes down to things like money. And that, but if it's family court, it may be issues of custody and so on. But think of a Venn diagram. We've got all these interests that one party has in one circle, and all of these interests that another party has in the circle. The first thing I do as mediator is I go, where do those interests overlap? Because those are the ones we don't have to spend a whole lot of time or money discussing. That's where the parties are in agreement. The more I can get those two circles to overlap, the more likely the parties are going to settle. But because it's voluntary, even if the mediator is doing a poor job trying to strong-arm somebody into settling, the answer is you can walk away from mediation and just never use them again.
I have to jump in here for a second. This is like a huge moment on Google+. Don Peterson said, not because of what he said, Tina made an excellent point, show them that you're ready to try the case or even move for summary judgment. I don't know if I said that, but I definitely I feel that way. And I actually want to have my clients maybe watch this video again, my potential clients, because hearing, my clients, I know their cases, and that becomes clear. I know them from extensive discussions. I keep a low caseload so that I can. But anyway, Don Peterson has a photo now.
I noticed that. He actually has a photo. Let's hear it for Don. We can see his face. He doesn't have like a horns or a third eye growing in his head.
Like
so that's
the most famous blue man photo in the history of the world. I mean, it's, yeah.
The elusive Don Peterson. Don, good to see you.
Yes, you look great, Don. And he's, oh, by the way, Kimberly, he is also an Orlando attorney. He handles FDCPA claims. So, he's someone, and he's a good guy, but yeah, he's had the blue man photo on Google Plus for a long time.
Meaning no photo, yes.
Yeah, meaning no photo, and there are plenty of those, but most of them aren't that active. But Don Peterson has just stayed active, and he just believes that. I won't even get into his beliefs, but it's a privacy issue. So anyway, I'm glad to see his photo.
You said Blue Man. I thought you meant Blue Man Group, and I thought, uh-oh.
Yeah. No,
it's not to do that.
Circle, right?
Anyway, sorry for the sidetrack.
That's okay. No worries. Kim, questions for you. When we're talking about now, let's get down to some brass tacks in terms of negotiation skills that work, that you've seen work as a mediator. And to set this up for the audience, and I'll post some of these articles later on in the comment threads. They're essentially 4 principal ways of responding to conflict, which is avoidance, impasse. I'm just not going to do anything, therefore we're never going to get anywhere.
That would be my husband, by the way, dealing with his customers.
Yeah.
That is his approach.
Like that. It's frustrating. Or giving in. Whatever you want to do. Whatever you want to do, they just give in. Competition, and this is where we see lawyers fueling this a lot. It's very adversarial. Yes. And then lastly, what we're trying to accomplish as mediators, right, Kim, is compromise. There are 4 principal ways. So as a mediator, how do you get these people off of 1, 2, 3, particularly competition, and on towards compromise?
Well, first, I never use the word compromise. I don't know why. I just shy away from compromise because I think it already sets the wrong tone. You're not compromising. You're making an informed decision because you have found common ground with your adversary, perhaps for extraordinarily different reasons. One person may be doing something for one reason, and another person may be doing something for a completely other reason. The classic illustration is the two little boys who come home from school, and they both want the orange. And the mom says, well, I only got one orange. What do you want me to do? And my suggestion would be ask why. Why do you want the orange? And if one child wants the orange because they like the pulp, and the other child says, I want the orange because I saw this great experiment I could do on the rind, well, that's win-win because we've got this common ground. And so you talk, you find out the why. If I had all the time in the world, that's all I would do is ask why, explain it to me. But we don't have all the time in the world. So frequently what you have to do is take those cues that you get from either pre-mediation statements or from tracking the attorneys down beforehand and saying, talk to me about something I don't understand, which I will do. I will track you down to the ends of the earth if I don't understand something. Or in the joint session, and then in the private caucus, planting the seeds for where they're going. If you don't solve it here, it's time, expense, and risk.
If I may jump in for the benefit of some of our non-lawyer viewers, you mentioned private caucus, and folks, what Kim is talking about is the structure usually will be everybody is meeting in one central location and having a discussion across the table and a presentation. But then oftentimes after that, you'll break folks up into their respective groups, where the mediator will start meeting with them privately, caucusing, finding out anything that the party wants to share in the case, keeping that in confidence unless the party says you can share it, and then taking settlement offers, asking questions, things of that nature, to meet privately with other parties as well. Kim, did I leave anything out there?
No, that's correct. Hoping you're going to get a little bit more candor. And that they're going to be a little bit more receptive to the conversation. And
a little less posturing, too.
And a little less posturing.
Yeah.
And when somebody says to me, I don't want to be here, I don't care, I'm not doing that, the question always, in one way or another, is why. Tell me why. How does this serve whatever it is, whatever the need is that you want? And so you open up the conversation. And you find out, well, okay, you won't do it under the circumstances that are being defined by the other party, the adverse party. But what if the circumstances were changed? And what if this happened? Would then I'm not doing anything, I don't want to be here, would your attitude change? Well, maybe. When you say, well, maybe, I got you, baby. Because that's a conversation. And so if you get that kind of there's just nothing here worthwhile discussing. It may ultimately end up being true, but mediation is a process, and the benefit of the mediator is the mediator doesn't have to take no for an answer. The mediator can go into there and say, define no for me. And it's getting to yes. As we were talking about that before, the classic books on negotiation is finding out why there's a no. And then working from there. And it's not at all uncommon to hear from two parties at the very beginning, Kim, this case will never settle. We're just too far apart. These people are crazy. They're difficult to deal with. And I get in and realize that what's happened is they haven't had a civil conversation for 3 years. Well, that's a problem because you don't know whether it's going to be able to sell or not. You don't know what the other person wants. You don't know what they need.
I have a question. I want to pop in there with something else.
I ramble, so come on, jump in anytime.
Sorry.
And I hope that was responsive.
Well, about personal injury, I'm just wondering, in terms of pain and suffering. I mean, obviously, that's the most difficult aspect of damages to nail down. And do you typically see plaintiffs' attorneys coming in with maybe verdict reporter decisions, or because how else would you? I mean, they just disagree. Right. Like the man who lost his leg. I mean, obviously, how do you convince him that this insurance company that thinks he's doing great, what do you do to guide people, and how do you even make a judgment in terms of pain and suffering?
It's a good question. It's one I'm still working through. I don't see a lot of people coming in with verdicts, but then I don't see a lot of people who are as prepared as I think they should be. If I think I am going to be mediating a case in which there is a serious disparity in the evaluation, I might do the jury verdict research. And I might bring real-life cases in and say, look, this was a year ago in the same venue with the same judge involving very similar damages. Now, you know, it's apples and oranges, we know, because you really can't compare cases. But I had one presentation I did when I went over 2 years' worth of spinal injuries, not involving paralysis, with or without surgery, and found out that they actually the verdicts did come down in different ranges depending upon different elements. And I was able to isolate 4 elements that made the difference between a $100,000 case or an $800,000 case or $1 million case. And it wasn't surgery and it wasn't medical expenses. It was other things that were something that you probably should think about, but maybe didn't put as much emphasis on. One of the things you have to recognize in mediation is no matter how stupid you think the argument is, somebody could buy it. So as long as it doesn't
Isn't that the truth?
Yeah, as long as it doesn't completely ruin your credibility to go repeat something like that, to show somebody a verdict and say, look, I know it's apples and oranges, but don't tell me this can't happen. And don't tell me that there isn't a pattern here. And when it comes from me, from the mediator, I think at least there's a courtesy of listing. When it comes from the advocate, I think there's a suspicion that the advocates only pick the ones they want, and it doesn't mean anything. But I'd be surprised who isn't running back to the drawing board after the mediation, seeing if that's true or not. So I personally feel they have a greater impact, both on allowing a party to evaluate their own claim and influencing other parties, adverse parties, to adopt your evaluation. If you have good verdicts, and by good verdicts what I mean is things that seem exemplary, things that seem similar, you can say, not saying it's going to happen here, it just can happen. Because this is all about risk. I have no idea what your outcome is. But we can talk about time, how long it's going to take to accomplish something. We can talk about risk, what the risk is that the outcome isn't what you want, that it's something else entirely. And we can talk about expense and all of the effect that that has on expectation. And all of the opportunities that you have through mediation that you don't have through litigation that can affect those factors. Because most people do care about all or at least one of those factors. Did that answer the question? Am I rambling?
Yeah, I think that was great, and I'm sorry again for cutting you off. I thought you were finished, but anyway, that was a great answer. So.
By the way, I'm going to throw in something here that is completely unrelated because we can do that. Amy Long says, Stephen Funeral, please tell me you're not drinking coffee at this time of day.
It's crazy.
I am drinking coffee. Mr. Vogelman is right about me burning the midnight oil.
My God.
Up late, out the door, halfway across the state of South Carolina, hearings this afternoon, back doing this afternoon, and then I'm going to mow the backyard. So let's hear it for Colombian bean, okay?
I would drink it all day long if I could get away with it.
Yep. So, and if it's too hot, I'll throw some ice cubes in there, and we're all good.
Oh my gosh. No, Amy, I'm with you. I can only have a morning cup of tea, and that is it. Even if I have a second cup of tea, I forget about it. I won't be able to sleep that night. Coffee I can't even drink 1 cup, so.
It does not affect my sleep at all. I can have a cup before I go to bed, and it just doesn't matter. But there's that compulsion while you're working to keep drinking it. I don't know why.
I do it. I do it as well. It's a habit I picked up in the military where we would heat up water literally in steel pots on engine parts. So anyway, I'm very much digressing. Kim, got a question for you here. Well, actually, Tina and I will both have questions for you. And we don't mean to blindside you here. If you've watched the show, then you may have picked up on the segment we do when we have individual guests who are lawyers. And this segment of the show is called Cross-Examination. Now it's personal. Okay, so the first thing we need you to do is raise your right hand. And I am a notary, and I'm going to swear you in. Do you swear to tell the whole truth, nothing but the truth, so help you Google.
Absolutely.
Okay, all right. So in this segment here, we get to ask you whatever it is we want to ask you. We won't ask you for your Social Security number or the PIN number for your debit card, but we may hit you with a few other ones just so our audience finds out a little bit more about you. Tina, what do you have for Kim right off the top of your head?
Well, I'm wondering sincerely whether her mediation training and experience helps her in her personal life, and in what ways she's noticed maybe a change since she's transitioned from being a lawyer into being a mediator, and, you know, has it helped you?
And actually, I think it has, because as Stephen started out the discussion, mediation applies to all aspects of your life, whether you're in a play yard scuffle or invading a sovereign entity. I find myself being much more patient. I find myself being much less decisive because I can see things going both ways. I end up playing the devil's advocate so much that by the end of the process, I just go, I don't know. I don't know what's going on. And when I talk to my husband, I tend to say, you need to go do this. I tend to, rather than say that, I say, honey, would you please do
that's awesome.
Yes.
Or it would be so wonderful, and I would be so happy, and it would make my day if this would get done.
Absolutely. So, listen, it does help, doesn't it? It does.
Yeah.
And if I can jump in on that a little bit, Tina, not only does it help in personal life because you're learning, you know, I don't know how it is in Florida, Kim, but in South Carolina, your mediation training, for example, if you're circuit court civil, you do that for 40 hours, a solid week.
Same thing.
And if you want to do family court, it doesn't carry over. You got to do 40 hours. You're out of the office for a solid week. And part of that is talking about the psychology that people have regarding how they bargain, fear-based bargaining, etc. Think of a lot of the principles that you might see if you picked up, say, getting the yes. And so, Tina, not only do I think that it helps for your interpersonal skills, although some days more than others, it also helps you as a lawyer, I think, because it gives you a better perspective on how to work to those same principles even without a mediator, how to work and negotiate with your clients. Because let's face it, we're also doing the same thing with clients who want us to do things that the law doesn't allow us to do, or their goals might be not entirely reasonable. So it's great training all around, don't you think, Kim?
Oh, absolutely. And I always thought when I was litigating that I was one of these litigators that was very good at looking at both sides and being objective and saying, okay, they've got a point, the other side's got a point there. But in mediating, I see it even more. I see if you open up your ears and listen and recognize that there's some merit to what they're saying, it makes you a better lawyer because you recognize, I'm going to need to respond to that. I'm going to need to take that seriously. And I think it makes you a better lawyer if you have had a chance to sit in both rooms, because you can imagine it as a lawyer, as we always do, what's the other side going to throw at me, but you really don't know what it's like until you sit in both rooms.
Yeah, it's Tina. Also, it's kind of amazing when you think about it in terms of law school curriculum. They teach us so many different things: trial advocacy, case law, what have you. And I'm not aware of any courses out there, and certainly not as a requirement, that teaches a lawyer how to negotiate.
Yeah, well, I actually took one, believe it or not. But
I'm sure they're out there. It's mandatory.
Yeah, and it actually was, I was a visiting student. It's a long story, but I was at BYU, and maybe they're kinder, gentler out there. But I did have, it was an excellent course. We read Getting to Yes, and we actually took Myers-Briggs tests, and then went through a lot of different aspects of mediation. And one of the things is repeating back what the person says.
Yep,
so
which is a nice way of saying "I hear you" instead of going "I hear you." Yes.
Yeah. Right.
But it works.
And I'm like Kimberly. I mean, I really do. And I used to be, work for a huge defense firm, and so I definitely know a lot of what they're going to do and what they're thinking and what the real risks and dangers are. I mean, those are just realities, so it's hard to not think about them. I mean, I try to, so of course we all think that we were aware of the other side argument. You would just be stupid not to be aware of them because they affect what's going to happen with your case, definitely. But I was just wondering, I mean, I don't know that I've noticed it. I'm not so good when it comes to this whole husband thing. You know, it's like,
it works, though. Think about it. Like, for example, the principle of, what is it? Think and double think. Okay, what is it the other side wants, and what is it the other side thinks that I want? And I do that with my wife all the time. Trust me. All the time, in a positive way.
Right. Well, no, I think it helps. I think it helps to talk to people civilly, and you get what you want. So.
Yeah. Most of the time.
Right.
All right. So we're coming down towards the end here, Kim. Now, my favorite question is for each and every lawyer we've had on the show. I have asked them to candidly share with us their most embarrassing moment as a lawyer, and I won't tell you which episode it's in, but I've shared one or two of mine as well, so you're not the only victim here. So as either a lawyer or a mediator, what is your most embarrassing moment in the field of law?
My most embarrassing moment. Oh.
And I can toss out examples for you if you want. Everybody has one. Referring to the wrong client during a hearing in a case, tripping and falling in front of the judge and jury. I've done that a couple of times. What's your? I always go for the sympathy factor, right?
I've had lots of moments of disappointment. I shouldn't say lots. Moments where I go, why am I doing this? But I think the most embarrassing was years ago. This would have been back in the 80s. I was before a judge, and I was arguing some point, I thought, extremely eloquently. And he interrupts me and he says, "Miss Sands, I do not allow men to go sockless in my courtroom. I will not let women go without stockings." And the sad thing was,
you are kidding me.
The sad thing was, I was wearing stockings.
Oh no!
So I didn't know where to go with any of that. I just thought, okay, sit down. That's it.
See, this is where I'm going to prove I'm not a mediator. I've been like, Your Honor, and I've been stretching the thing. Well, maybe not. I don't know.
Oh, that's funny. And, that's great, because all that time you think you're just putting out all this great argument, and you're wowing them, and come to realize the only thing he or she is looking at is your feet, right? That's just.
Well, and the other guy's feet.
The other guy's feet.
Whether he's wearing socks.
Obsession. Yeah. All right. Well, that's good. All right, Miss Tina. Well, Kim, do you have, why do they call it elevator pitches? I don't know. But, Kim, do you have an elevator pitch, anything you'd like to give to the folks out there? If you want to stick around afterwards, I'm sure there'll be some comments and questions, but anything you want to throw out to our audience regarding your mediation services? This is where you get to shamelessly promote yourself.
And that's the thing I'm worst at. Let me just say this about that. I have spent many years, let's begin with the story of the stockings. I have spent many years dealing with what I am rather than who I am. Beginning with having to figure out how to be persuasive in front of a jury when there were many women litigators. And I never looked at it from the point of view of being a weakness. I always looked at it from the point of view of being a strength, because it is what it is, and it's going to have to make me stronger. And I feel that having to reconcile that over the years, where we're not treated so kindly as I hope we are now as a member of this profession, I think that all led up to truly enhancing my persuasive abilities. And so I don't care what you throw at me. Actually, the more the better. I love mediation. For for the personal enjoyment of it, because no matter how similar the cases are, the human dynamic is always different. And I enjoy helping people solve their problems. I enjoy getting a good outcome for both sides. And I think I'm good at what I'm at. And I think as a woman, I've had to exercise for many, many years a lot of skills, had to develop and exercise a lot of skills that are part of what we're talking about here today. Not that men don't, obviously they do. The mediators that I know are great guys for the most part because they have learned that art of listening.
Wait, are you sure? Most of the men I know don't do a very good job at that if you ask their wives.
She's being really nice. Showing that she's a mediator right now.
Yeah.
In her pitch.
Yes.
Yeah, the mediators that I know. But I got 30 years experience on them. So that's a smile, or that's a frown upside down. And so if I have any pitch, I used to also get, when I first started mediating, well, Kim, I think you're great, and so I've got this case that needs a woman. And I thought to myself, well, I appreciate that. I am one. I'd be happy to mediate your case, but I also mediate other cases. I've also noticed that whenever I'm in the room, I tend to suck all the testosterone out of the room. The first case I mediated, first case I mediated was it was a legal malpractice claim. There were like 5 law firms and 5 attorneys per law firm, and then an attorney per law firm. And the testosterone in the room was so thick you could cut it with a knife. And I actually think in that instance, nobody felt in competition with me. Everybody felt like they just needed to plead their case with me and make me happy with them. They didn't feel like they needed to be in competition with me. So I was able to separate, because obviously getting them together was not very constructive. Separate and have a conversation with them that I don't think they would have been able to have with a male mediator. Could be wrong, could be reverse discrimination, but it's just nice after 30 years to look at the journey and say, well, I am where I'm supposed to be, and I'm doing what I'm supposed to do, and I'm doing it well.
That's great. That's great.
We have a lot of people. I just want to thank everyone. Stacy Roberts saying another great show. Glad I was able. And by the way, she is a mediator out in Utah. Though I don't know her exact story, but I know she was either in Florida or a Florida attorney for some period of time. I think she moved from Florida to Utah. And then Christopher Vogelman is always fun. He's saying thank you. Christopher Pearsall, who made many comments during the show. Thanks so much for joining us. Ray Miller, who's a huge supporter. He's yet to watch one of our shows and not learn something. This is one of my favorite shows, and I recommend it to everyone. Those are just the comments I can see. Oh, and Christopher Vogelman, always a comedian, is going to never forget that I said I'm not so good when it comes to the whole husband thing.
Yeah, well, remember, I do family court mediation. You and John can just get me on the line, right? I'm not certified in Florida. Actually, for that, you'd need Kim.
So it makes up for what I lack, so that's the good news.
Yes.
But well, anyway. Listen,
I want to give another quick shout out to Rocket Matter, the leading cloud-based solution for law practice management for small to mid-sized firms. If you're in the market for an excellent cloud-based practice management system, consider Rocket Matter by visiting www.rocketmatter.com. And Tina, Kim, thank you.
Well, I
don't have to thank you.
One more.
You're the one who puts all this together for us. So.
Wait, I want to say one more thing. I just want to give a shout out for us for next week. Christopher Pearsall is going to be on with a sex therapist. Her last name is difficult to pronounce, but it's Gonzalez or something. She's really good. I've seen her before, and we're going to be discussing infidelity and how that relates to, family law issues. Christopher Pearsall is a Rhode Island family law attorney, and we've never seen him or met him, although he's very active on Google+. So I'm really looking forward to that show next Monday. So
you had me at sex therapist. Did that, ladies? Did that come across as misogynistic? Because Tina will testify. I'm not that way. I just
I'd be a sex therapist too.
I didn't know we had a sex therapist out there, but I'll be there. Apparently, I'm there.
That's infidelity. The topic is going to be infidelity and how that relates to family law court, but then also I don't know yet what she's just going to tell us some of her insights into how it affects marriage, or obviously not in a good way.
Somehow I have a feeling
maybe for some people it is in a good way. I mean, we're going to find out from her.
Hard to say. And Kim, Tina, somehow, and of course Tina knows Christopher Vogelman. Kim, you're new to this, but if we're going to have a sex therapist on there, somehow I have a feeling that we're not putting much, if any, comments by Christopher Vogelman up on the screen during that podcast. So anyway, with that, ladies, I'm getting ready to end the broadcast. Listen to the supporters of Legally Speaking. Honestly, y'all are the reason why we do this each and every week. Y'all know it's a lot of hard work to put it together. We're not complaining. We're proud to do it. We're happy to do it. And so we really appreciate everyone's support and for tuning in and sharing and so on. So we look forward to you next Monday at 4 p.m. on Legally Speaking. And thank you, everyone. We'll see you next time.